Good morning, everybody, or afternoon, depending on where you are. My name is Tara Ficken. I'm an attorney in Husch Blackwell's Intellectual Property Group. Before we begin, I've been asked to cover a couple of housekeeping items, so please bear with me. At the bottom of your audience console, you should see multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the Q&A button. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, we will answer your question later via email. Has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, you'll be prompted to take a short survey. Please do so. We appreciate your feedback, and we do use that feedback to plan future programming that is most applicable to your business and your business needs. That's it for the housekeeping items. So we'll go ahead and get started with the actual programming. Joining me today is my colleague, Shelby Dolan. Shelby focuses her practice on intellectual property and data privacy legal issues. She's going to be covering some promotions-specific privacy considerations and best practices later on in the program. But to get started, I'm going to talk to you a little bit about promotions law. So just a brief overview, we're going to look at the basics of promotions law, the differences between sweepstakes, contests, and giveaways, best practices for running promotions, traditionally some special social media considerations, advertising a promotion and how that is supposed to go. And then we'll go through some what I think are very fun examples of when promotions go wrong. After that, we will take a look at some of the laws applying to digital marketing campaigns and privacy-specific promotions considerations. So to start, let's talk about where promotions laws come from. It's actually a fairly complicated subject. Promotions laws are governed by an amalgamation of state law, federal law, and regulatory guidance. The state laws that are applicable depend on who is allowed to enter the promotion. So if you're running a promotion where entrants can come from any of the 50 states, then all 50 states' laws technically apply to that promotion. It's for that reason that when we're drafting rules for a particular promotion, we try to take the lowest common denominator and make sure that you're not going to run afoul in a particular state because of one specific intricacy. And some of the states do have some fairly intricate exceptions to certain things. We'll cover a few of those in the presentation today. There are also federal laws that are applicable, things such as CAN-SPAM, CCPA, and the Tcpa, which Shelby is going to talk about later in the promotion in more detail. And then there's also regulatory guidance and enforcement through the Federal Trade Commission, who focuses more on consumer promotion and trade activities. There's also the National Advertising Division of the Better Business Bureau. They focus more on false advertising claims, but they have certainly been involved in promotion-specific enforcement in the past. And even though it's a non-federal governing body, they do have a lot of influence in that space, and they offer a lot of guidance and rules for companies to follow when they're putting together these types of promotions and the advertisements for those promotions. So we're first going to have a little discussion here about why words matter. The main issue when we're talking about running a promotion is you do not want to run an illegal lottery. Obviously, the word illegal is in the title, and that should explain why you don't want to do that. State law imposes civil and criminal penalties for running an illegal lottery, and each state has its own definition, but essentially they all boil down to these same three elements. If a promotion has consideration or an exchange of something of value for an entry into the promotion, if there's a random drawing element and there is an ultimate prize at the end, it's considered to be an illegal lottery. So to run a compliant promotion, you need to remove one of those elements from the promotion in order to not run afoul of these particular laws. And the element that you remove is what makes the legal distinction between a sweepstakes and a contest. So what's the difference here? In a sweepstakes, you remove the element of consideration. So in a sweepstakes, there's a random drawing element for a particular prize. Typically, when we say remove consideration, there's that no purchase necessary language that we're all used to seeing out in the world when we're dealing with a promotion scenario. If we remove the random drawing element, but we keep sort of a pay-to-play structure, require an entry fee, something like that, then it's considered to be a contest or a contest of skill. These are both distinct from giveaways, where everyone is the winner of a prize if they complete a certain set of criteria. Typically, it's something like the first 100 people to comment on this post will get a free t-shirt, or the 100th person to call our radio station will receive tickets to this event. Consideration is permitted for giveaways as long as it's disclosed up front. And again, it's a very clear and conspicuous disclosure. Finally, a special note about raffles. I have clients all the time that want to say, oh, we're having a raffle for a particular prize. That's very dangerous. Raffles do have a very specific legal meaning. They are basically occasionally permitted illegal lotteries. Only charities can legally run raffles in most states, and there are specific requirements for doing so. Raffles are a little outside of the scope of what we're going to be talking about today. We're going to be focusing more on traditional commercial promotions, but if you are a charity entity and you do have specific questions about running a raffle, please let us know and we'll be happy to reach out to you and connect offline. So obviously a big question comes down to defining consideration, and it's traditionally thought of as a pay-to-play structure. But it's not just the exchange of money. It's a state-specific determination, and many states have taken a much broader view of what this term consideration means. So typically, instead of just thinking about it in a monetary context, we want to think about it as either a benefit to the person that's conducting the promotion or some sort of inconvenience or disadvantage to the entrant. If they're giving up something such as a significant expenditure of time in order to participate, that could be viewed as consideration in some states. Some popular examples that I see quite often are something like filling out a survey in exchange for a sweepstakes entry, travel to a particular venue or even a trade show that's only offered in one location, previously at one point in time has been considered consideration. Even something like signing up for a free account or requiring someone to sign up for something in exchange for an entry. That's a little more complicated. If it's a free account, it falls on the relatively low end of the risk spectrum. However, I do say that best practice, if you're wanting to get people to sign up for a loyalty program or something in exchange for an entry, best practice is to limit the eligibility to those that already have an account as of the start date of the promotion. And you can use the time leading up to the promotion to try to get as many people to actually get those accounts in place so they can participate at that time. There's also been a question about whether requiring a person to go online may be consideration. A couple of years ago, there was actually a court case, I think it was back in 2011, that was dealing specifically with this issue of if you require someone to go online to enter the sweepstakes, is that considered an unfair advantage to them? Not everyone has internet access. And at the time, that was true. As of 2018, it looks like roughly 89% of the American population were found to have access to internet either in their homes, on their smartphones. So I think that question has become a little more moot, but it's not 100%, and we've never gotten official guidance from anyone as to whether that is valid consideration or not. So something to keep in mind as well when you're thinking about how you're wanting people to enter into your promotion. Now, that's not to say that you can never run a sweepstakes that has a consideration element, but if you're going to do so, then you need to provide a free alternative method of entry. Typically, this is a mail-in entry option or like an online entry form that people can go to. It must be provided an equal chance of winning as any other entry method. I think a lot of clients, obviously, you want to run a compliant promotion, so for marketing purposes, I understand that offering a free method of entry where they don't have to go through the steps that you're wanting them to go through is not ideal. However, many clients, I think, go with the mail-in entry option as kind of a subtle way of discouraging that. It is a hassle to have to go to the post office and mail a letter, get a stamp, all that kind of stuff. So It often does not actually end up affecting the participation in the promotion. And it's really important that you not be found to run that illegal lottery. So if a sweepstakes is really what you're wanting to do and you're wanting some sort of, payment of they have to purchase a particular product or something like that, this is unfortunately required. And you see large companies all the time do this kind of thing. So you're not alone. Let's talk for a minute about prizes. Every promotion is going to have a prize, otherwise you wouldn't be running the promotion. But there are certain things with prizes that you should be aware of. When you're dealing with regulated products as prizes, you may have some additional hurdles. So these are things such as alcohol, cannabis, tobacco products, etc. You want to make sure that if your prize is one of those items that you have your eligibility limited to the appropriate people. So if you're giving away alcohol, for example, your entrance should not be under 21, and that needs to be specifically stated in your rules. There also could be reputational issues for offering those kinds of prizes. So you just want to, it might seem like a very tempting, trendy thing to offer some of these products, but you want to make sure that you're thinking through them entirely before you get your promotion out there. Prizes should also be clearly and accurately described on all of your materials. And keep in mind that there can be IP issues in describing prizes, particularly around the use of brand names and logos. Unless you have specific permission from the brand owners of your prizes, we do not recommend using brand names or logos in the description of the prize. And some brands actually are very militant about not allowing people to use their brand names. Apple is one of them. You can say that you're giving away a tablet. You cannot say that you're giving away an Apple iPad. They have actually gone after people for that before. And the reason is that they want to avoid implying an endorsement or an affiliation with their particular brand, especially if it's a promotion that's just completely outside of their control. So for that reason, we do recommend using the generic names as much as possible. And keep in mind too, for instance, koozie is actually a registered trademark. I get that a lot. If you want to say that you're giving away a koozie, I would recommend saying an insulated beverage container or something like that, a beverage holder, instead of koozie, because it is actually a registered trademark. So keep in mind, just because you think something is generic, that doesn't necessarily mean that it is. So I recommend checking with your IP counsel or your legal counsel to make sure that you're not getting yourself into hot water. And also something to keep in mind is that winners should not have to pay shipping and handling to receive the prize. That in some states may be considered post-consideration. So if you're going to have shipping costs associated, I recommend building that cost into the value of the prize that you're giving away for reporting purposes internally. There are also some special prize considerations when we're dealing with travel prizes and money prizes in particular. For travel prizes, you need to make sure that what's included and not included in the travel plan is very clear in the official rules. You want to make sure that you are specifically delineating, is the flight included? What type of flight? Is it first class or is it coach? Do they have to travel on certain dates? Is the prize for more than one person? Do they have to travel from the same location? Where are they going to be staying? Are meals included? What about ground transportation? All those kinds of things need to be included to make sure that there's no question as to what the winner is responsible for and what you are providing. You also want to make sure that to prevent that ambiguity, you're very clear of if you're picking the travel arrangements and you're literally just handing them a packet saying, here's all the details you need for your trip. Congratulations, have a great time. You want to make sure that they know that and that they don't get to pick the hotel or something like that. So you just want to make sure that you're very, very clear. And when we're talking about money prizes, you want to make sure that you're thinking about how that prize is going to be awarded and disclose that. So is it going to be cash? Is it going to be a check? Where you're going to do a wire transfer? How are you going to get that money from you to the winner? And you also want to check for an internal policy at your place of business. Some have policies against giving cash prizes for commercial promotions, and some of them even go a step further and say that offering gift cards can be considered a cash equivalent. So you want to make sure that not only are we looking at sort of the external laws and regulatory scheme, but Your place of business may also have some internal policies that you also need to be aware of. So you always want to check with your legal departments and make sure that you're following their guidance as well. So this is the toolkit that you need to run a sweepstakes or a contest. You're going to need an official rules or terms and conditions document. This document is going to contain all of the relevant information pertaining to the sweepstakes or contest. So it's going to talk about who is eligible to enter, what do they have to do to enter, what the dates of the promotion are going to be, what the prize is and the value of that prize. And we're talking about the retail value. We're not talking about the value that you obtain the prize for. So if you obtain the prize at a significant discount from a business partner or something like that, that's not the value you want to use. It's the value that a consumer would need to spend in order to get that prize or an equivalent prize. Your rules are also going to contain dispute resolution proceedings and who is the sponsor of the promotion. Once these rules or terms and conditions are finalized and published, they should not be changed. It's particularly anything dealing with sort of the material elements of the promotion. So how is somebody going to enter, when the promotion is going to take place, all of those things should remain in place. You do expose yourself to risk by changing them after the fact. However, sometimes, particularly as we saw after the pandemic last year, there are potentially reasons that you might need to make changes to that promotion. If it's something in the material side, I recommend discussing that risk with the appropriate business people and your legal department and make sure that everyone's on board in terms of where that risk is going to be shared. We have started building in some additional flexibility into our official rules, talking about, for instance, if a trip prize cannot be offered or claimed because of an ongoing global pandemic or something like that. You know, it just gives the sponsor of the promotion a little more flexibility to offer an alternative prize, to hold the trip until such a time as it can be offered, that kind of thing. You will also need abbreviated rules on all marketing materials and advertisements. That includes social media posts that are trying to get people to participate in a given promotion. The abbreviated rules document is basically just a very condensed version of the official rules. So it sort of hits the highlights. Who's eligible? How do they enter? When do they have to enter by? What's the prize and the value? And it usually provides a link to the full form official rules that are posted online, or if they're not being posted online, the contact information for who someone can reach out to get a copy of the full rules. On some social media platforms, particularly Twitter, there are character limits that may necessitate using a much shorter version of the abbreviated rules. I only recommend doing that under very limited circumstances. There is no official guidance that is appropriate or what has to be in those very, very shortened rules. Usually it's no purchase necessary, eligible 18 plus, enter online at this link, and then full details here, and provides a link to the full official rules. So use that very sparingly if possible. If you're posting an image, you can always put the full abbreviated rules in fine print in the image itself and use the actual content of the post for your marketing and creative language. But I do not recommend using those unless absolutely necessary and there's some practical limitation that you just can't get around. You'll also need a winner's release, which is going to confirm eligibility of the winner to receive the prize, confirm that they have complied with all of the terms of the official rules. And it may also include publicity release language if you're planning on doing anything with the winner's entry materials, if they submitted materials to be a part of the promotion, or if you want to publicize their name, take their picture, put it on social media, all that kind of stuff. A quick note, and this is one of those intricacies that I was mentioning earlier, Tennessee actually prohibits requiring publicity release language to accept a prize. So if you have a winner from Tennessee, you may need to actually revise your winner's release to take that publicity release language out and seek a separate publicity release from them. And finally, there are tax issues that need to be addressed when you're running a sweepstakes or a contest. Any award over the value of $600 needs to be reported to the IRS, and you need to issue the winner a 1099. If you have more specific questions about that, I recommend speaking to your tax counsel or your tax preparer. They definitely will know more about it than me. I just know enough to say you have to do it and that you should talk to your tax person. Sweepstakes registration is a very big annoyance for many marketing departments and legal departments alike. Essentially, if the total prize value is over a certain threshold, certain states require you to register that commercial promotion with the Department of State or the Secretary of State's office. Rhode Island is probably the most common because the threshold is so low. So anything over $500 actually needs to be registered in the state of Rhode Island. It's not overly burdensome. It's more just annoying. So it's a $150 filing fee. The registration paperwork has to be filed just before the end date of the promotion. So you can start your promotion and file the paperwork after so it doesn't hold up the process. And there's no bonding required. That is in stark contrast to New York and Florida. Both of those values are over $5,000, which is admittedly a fairly high bar if you're offering a high dollar value item. However, it's the timing of the registration paperwork that makes them more trouble. New York in particular has to be filed 30 days in advance, which I understand in the marketing world is an absolute eternity. Unfortunately, there's nothing that we in the legal department can do about that. So if you're wanting to run a high dollar value promotion in New York, you need to keep that 30-day registration requirement in mind. And you also will need to get a bond for the value of the prizes that you're giving out. In Florida, it's only 7 days, so it's a little more reasonable, but it does still need to be in advance of the start date of the promotion. So keep that in mind for those jurisdictions if you're targeting a promotion or if you're wanting to include those states in your specific sweepstakes. The easiest way to get around this is to exclude those states from being eligible to win. You see that all the time where they say, you know, offer valid in the United States of America, excluding Rhode Island, New York, and Florida. You see it all the time in these kinds of promotions. Again, it's not ideal, but if you're on a tight timetable or if registration is just not something that you want to deal with, that's the easiest way to get around it. Oftentimes also sweepstakes can kind of be restructured to more of a giveaway scenario where instead of having the random drawing, maybe it's the first 6 people to complete a certain set of criteria are going to win the prize. Giveaways do not require registration. These are only for sweepstakes. So that's another way that you can maybe get around this additional hurdle. When we're talking about contests, you need to think about your entry methods. They have to include some element of skill. So again, there can be no random chance involved in determining the winner. And entry methods should not include dangerous or illegal activities. I include a picture of a water bottle here because I'm sure many of you remember back in 2007, there was a media sensation when a woman entered a radio station contest called Hold Your Wee for a Wee. It was very classy. And basically contestants were to see how much water they could drink over a period of time without going to the restroom. No one ever found out how much water she drank, but she did win and then was found dead in her home several hours after the close of the promotion. And apparently she had died of water intoxication. Obviously, the reputational damage alone was swift. Many people were completely outraged by this scenario. How could someone not think that that was dangerous? And the radio station was actually sued for wrongful death, but the court found that they were not actually guilty. So there were no criminal or civil monetary penalties. But something to think about. People were fired over that promotion. It was definitely a media debacle. So you want to really think through what you're asking people to do in exchange for this entry into a contest. When it comes to public voting, I tend to discourage using public voting as a way of determining a contest winner. The primary reason is that it's difficult to ensure that the general public is adhering to your set of judging criteria that you are enumerating in your terms and conditions document. The placement of the entries in itself has been said to affect voting, so people can log on and they select the first ones without really looking at all of the entries in a particular promotion. And because it's usually online, it's difficult to eliminate the potential for cheating, people putting bots together to make sure that their loved one or their friend is the one that's going to win. So if you really want to include public voting as some sort of audience engagement tool, I recommend doing it as kind of a two-tier process. So you can have public voting to narrow it down from all of the entries to the top 10. And then you have a set judging panel that has the judgment criteria and make their official decision out of the top 10 from the voting, from the public voting. So if that's something that you really feel strongly that you need to do, I just recommend that it not be the only determining factor in who actually wins the final prize. And again, I've said it numerous times, but keep in mind that if there's some sort of tie, you cannot use a random chance drawing method of any kind to select the winner of the tie. That makes it a sweepstakes because you're choosing the winner by random chance. So you'll need to think of some other type of tiebreaker based on skill. Some radio stations use a math problem, for example, just something skill-based that you can use to determine the winner based on the tied entries. Giveaways are much easier to run than sweepstakes or contests. From a legal perspective, the amount of documentation that's required is a lot less, so I can turn a giveaway around a lot quicker than I can a sweepstakes or an official contest. Really, all you need is a short disclosure on the advertisements and marketing materials for the giveaway. Again, it's going to need to contain the salient information, so who's eligible, how do they enter, what do they have to do to get the giveaway. If there's any limitation on the number that you're giving out or how you're selecting who gets the giveaway items, what the prize is, the value of what you're giving away, and again, who is the sponsor of that giveaway. And again, there's no registration required. So really all you need is a short paragraph to tack on to a social media post or your advertisement that you're putting out, and you're good to go. A quick note about surprise and delight. So for those that don't know, a surprise and delight campaign is one where there's no advertisement ahead of time. It's just the brand does something for its consumers without really advertising it ahead of time. So it could be, you know, the first 5 people that post a review of their new product will get a little gift basket or something like that. Surprise and delight only works if you do not advertise it in advance. I know that seems simple, but oftentimes we get someone saying, oh, we want to run a surprise and delight campaign, so we don't need any of the documentation, but then they want to advertise, hey, we're going to be giving away something mysterious next week, and that spoils the surprise and delight. So it only works when you don't talk about it and you just do it. And again, if you do that, then there is no disclosure or documentation required from a legal standpoint, but you do still want to think about what you're giving away and if there's any implications from that. So if you have questions about surprise and delight, I'm more than happy to talk about it more separately. When it comes to who is the sponsor of a promotion, often that's a very easy question because it's the person that's soliciting entries, picking the winner, providing the prize, who is administering the actual promotion. But sometimes it might be tempting to go into business with a partner or another entity that your products kind of work together. And you might think about, well, we're both sponsoring the promotion, so we should be co-sponsors. Typically, I do not recommend co-sponsoring a promotion, and it really comes down to a question of liability. So ultimately, one party is going to be responsible for certain aspects, and the other party is going to be responsible for other aspects of the promotion. But the laws don't make any distinction for that under promotions law. So if your business partner makes a mistake and they were in charge of drafting the rules and they forgot to include a particular element or they did something incorrectly, you could still be on the hook for that mistake, even though it was sort of outside of your control. If it's a situation where you are just sort of providing a prize and you're saying, I'm going to give you this in order to give it away to your consumers, just to make sure they know that, we gave it to you. A prize provider agreement or some other contract between the parties can resolve that risk. And it basically just outlines, here's what we are responsible for with this promotion, and here's what you are responsible for this promotion. And, just sort of clearly sets the liability and the split of labor between the two. It's just a way to insulate your company from liability. So sometimes who's the sponsor can actually be an important consideration. And if you have questions about that particular relationship, make sure you reach out to your legal counsel. We're going to talk very briefly about social media promotions. So if a promotion requires entrants to submit material on social media, just know that it has to include a proper endorsement disclosure so that others know that if someone is submitting that material, they're doing it in exchange for an entry into a promotion. That can very easily be taken care of with a hashtag. And you just need to, in your official rules, require them to use the appropriate hashtags in their entry. You build that into your eligibility criteria and what they need to do to win. So it can be as simple as hashtag contest or hashtag sweepstakes. It can't be hashtag sweeps. The FTC has been very clear on that. It has to be the full word hashtag sweepstakes. Some clients can actually turn this into kind of a marketing opportunity. So you can make a clever hashtag that includes the word sweepstakes to sort of build your brand and use it as a marketing tool. So the hashtag why I give sweepstakes, for example. So you can definitely use it as a tool as opposed to just an annoying hashtag that they have to tack on that maybe takes away from the message that you're trying to convey. Keep in mind that user-generated content submitted via social media has to comply with the platform's terms of service, as well as any specific concerns that you might have for your brand. And you want to be aware that there are platform-specific rules and guidelines with regard to running a promotion on any of these social media platforms. Facebook, Twitter, and Instagram are by far the most popular, so I pulled some very specific examples for them here on the slide, but note that all platforms probably have these guidelines somewhere in their help section on the website. So, and they change pretty regularly. So you want to make sure if you're running a platform specific promotion that you double check those guidelines and make sure that you are in compliance with them. Probably the one that I get the most is from Facebook. You actually cannot require entrants to use their timeline or their friends list to promote a sweepstakes or a contest. So asking someone to share material on their timeline is not permitted, but you can ask them to submit material in response to a post that you have made on your own business page. So that's typically the way that I recommend soliciting user-generated content on social media, just to make sure that you're not running afoul of Facebook's specific rules. And keep in mind that all platforms do require a release of liability in the official rules. So make sure if you're drafting your own rules that include a social media platform component, that you include that language in there. When it comes to advertising a promotion, you want to make sure that you're including appropriate disclosures and disclaimers. So again, that's abbreviated rules for sweepstakes and contests, disclosure for giveaways. And you want to make sure that that disclosure is clear and conspicuous to the reasonable consumer. So typically I say no smaller than 8-point font, and it needs to be in a color that's going to be easily readable in the context of whatever advertisement it is that you're putting together. You also want to make sure that you're only using assets that provide enough space for proper disclosures. So if you have a sweepstakes, for example, where you are required to put sort of a bigger paragraph of abbreviated rules on there, it's not huge, but it's more than just a single line. You might not want to use tiny banner advertisements online to try to get people to that sweepstakes page, just because the risk involved in not physically being able to include the proper disclosures often outweighs the ability of using that particular asset. So just keep that in mind when, from a marketing perspective, you're deciding how you want to go about advertising that promotion. You also want to make sure that you avoid making what might be considered a claim in any advertisements. So if you're trying to get people to participate and say you could win up to $2,500, that up to language could be construed as an advertising claim, and you would need to be able to substantiate that and prove that all or almost all of the participants are going to win that stated value. So make sure that you're thinking about that when you're coming up with your creative copy in your advertisements. You also want to avoid using language that implies the participant's already a winner. I see a lot of an email blast where it says, click here to win. And the reality is they're clicking there for a chance to win. They don't actually win the promotion by simply clicking the link. So you want to make sure that you're not being disingenuous or misleading with that type of language. Any images that you're using in your advertisements, even of the prize, You need to make sure you have permission from the brand owners to do that and to include their logo or their brand name in particular in the image. And you want to be aware of industry-specific advertising guidelines that might provide additional requirements for you. So for instance, the Department of Transportation has authority over transportation companies like airlines. Banks and credit unions go through the Consumer Financial Protection Bureau. And there are state authorities over public utilities and insurance companies that you would want to check and make sure that they haven't also provided additional rules or guidance as to any advertising-specific issues. And just generally remember when you're advertising that transparency is the best policy. So you want to make sure that when you're coming up with these advertisements that you're being true to the terms of the promotion and what's being offered and how they enter. So ultimately, this all comes down to a risk tolerance decision. So what's the risk if you run a promotion that maybe isn't fully compliant with the rules or guidelines that we've already talked about today? So you do run the risk of a lawsuit. Less often, like I said, there is criminal liability. For instance, not registering a promotion in Florida and New York when it's required is a misdemeanor in those states. So that's always a possibility, not likely, but a possibility. You also run the risk of civil lawsuits from either disgruntled contestants, and disgruntled people will do some crazy things, or you run a risk of a lawsuit from a competitor for maybe some false advertising issues that I guarantee you they're watching what you're doing and they're waiting to see how you're engaging with your customers and making sure that you're doing it correct. And if you're not doing it correct, they're going to report you to the FTC or the NAD. They might even bring a lawsuit. So you want to make sure that you're thinking about that as well when you're putting together your plan for promotion. There's also enforcement actions by government entities, including the FTC and the NAD. We're going to talk about one of those in a minute. And probably most important is just the reputational damage. It's so easy nowadays to have any mistake you make publicized online. Consumers that don't win have access to social media platforms and other ways of tarnishing your brand with just bad-mouthing, how what you did wasn't fair, or, what you did wasn't in compliance. So you want to avoid that reputational damage as much as possible. So I'm going to take the last few minutes of my time just to go through some very quick examples of when promotions go awry. I don't know how many of you remember back in 2020, it seems like it was so long ago, but Draper James, which is a clothing company owned by Reese Witherspoon, posted a promotion on social media for teachers, offering teachers a free dress if they filled out this online form. They did say that there was a limited number, so it said offer valid while supplies last, but it didn't disclose how many they were going to offer or anything like that. Purportedly, they had nearly 1 million teachers submit a form to receive a dress, and it turns out that they only had 250 dresses to give away in a very narrow range of sizes. And obviously, this disgruntled teachers across the country in a time when teachers were being held up as our new national heroes. Virtually every major news outlet covered this story. Consumers were extremely upset to find out that there were so few dresses available and that there was no disclosure. And in fact, several of these disgruntled teachers got together and filed a class action lawsuit against Draper James late last year. They ultimately ended up withdrawing the claim. But in the complaint, they basically alleged that the promotion took advantage of the COVID-19 pandemic and, quote, used it as an opportunity to save hundreds of thousands, if not millions of dollars in marketing costs while building up a database of valuable consumer information. So while this lawsuit was ultimately withdrawn by the plaintiffs, it was withdrawn without prejudice. So there's still an unlikely chance that other people may come forward and try to take this one on. But the reputational damage took a lot of time for Draper James to recover from. They ended up making a donation of an unspecified amount to some education entities, and they offered free discount codes to everyone that didn't actually receive a dress. So it's just one real world example, very recent, of how your best intentions can very quickly go awry if you don't really think through these promotions from start to finish. There was also recently an FTC case that was brought with the state of Missouri against a sweepstakes scam company that was targeting the elderly. The defendants were sending out mailers to consumers around the world alleging that they'd won or were likely to win a prize in exchange for a fee. So, for example, it'd say, congratulations, you've won $2 million. You just have to pay us a fee of $149.99 and you'll get your money in the mail. Ultimately, this case settled with the FTC in 2019 for $30 million in cash and assets. It's actually the largest forfeiture the FTC has ever received in a sweepstakes scam case like this. And the bad actors are permanently banned from the prize promotion business in the United States in perpetuity. So hopefully none of you are running sweepstakes scams, but it is an example of sort of the enforcement power of the FTC, and there can be some very real monetary judgments against companies that act in that way. And finally, I would be remiss if I didn't very quickly mention the Pepsi Points case. It's one of my favorites. There was a televised commercial for Pepsi Points that showed a teenager landing a military jet in front of his school. And he gets out and throws on his backpack and walks into school and very coolly says, "Sure beats the bus." And it flashed Harrier Fighter 7 million Pepsi Points on the screen. So the plaintiff, being a very enterprising young man, used some crowdfunding means to raise $700,000, which was the amount needed to purchase 7 million Pepsi Points, and sent it off to Pepsi, and Pepsi didn't send him a jet. And so he sued, saying that he was owed a jet. The court ultimately found that that Pepsi did not owe the plaintiff a jet, as it was clearly puffery. No one could reasonably believe that they would sell a $23 million fighter jet for $700,000 in Pepsi Points. But this case went on for a couple of years. It was, again, reputational damage. It's a good laugh to us now, but the amount of money that they spent to argue this, when very, very easily could have included a disclaimer saying you're not actually getting a jet for 7 million points. And that's what they ended up doing. They retooled the ad and added a disclaimer at the bottom, basically saying you're not actually going to get a jet. This is just for vehicles. So that's a whirlwind tour of promotions law basics, and hopefully some funny examples of why this stuff is actually important. But I'm going to switch over to Shelby now, who's going to cover digital marketing and privacy considerations.
Hi there. As Tara mentioned, I'm Shelby, and I'm just going to walk through some privacy-specific considerations for promotions. First, I'm going to talk through some of the laws that apply specifically to your digital marketing campaigns, whether that's marketing that's through your emails, text message, or phone calls. So with email advertising, obviously many businesses use some form of email marketing for their promotions. And while many marketing teams know how to effectively send really great promotional emails, it's important to make sure that your marketing team is in line with your legal team and can recognize what those federal law requirements are that are in place for specifically sending promotional emails. So the main law to consider in this space is the Controlling the Assault of Non-Solicited Pornography and Marketing Act, which is also known as CAN-SPAM, which is much easier to say. So the CAN-SPAM Act sets the rules for sending commercial messages to consumers. The FTC has the authority to enforce CAN-SPAM violations, and a violation is subject to penalties up to $43,792 per email that is sent. And in addition to the FTC, state attorney generals also have the authority to enforce CAN-SPAM violations. So it's really important to keep in mind what it takes to comply with CAN-SPAM. So CAN-SPAM's application. Generally, CAN-SPAM prohibits false or misleading transmission of information in both commercial and transactional messages. But CAN-SPAM's primary focus is on commercial messages, which need to meet several requirements under the law. But the first step is determining what is a commercial message versus what is a transactional message. And the main question to consider here is the primary purpose of sending this message to advertise or promote your product or service? When answering this question, you can consider, is this message generalized? Are you sending it to many users at the same time? Are you pushing a user to take action with the promotional content? Are you encouraging a purchase? If you're answering yes to any of those questions, it's most likely going to be considered a commercial message under CAN-SPAM. And so in order to comply with CAN-SPAM, and when we're speaking in terms of promotions and sending a promotional email, it's usually going to qualify as a commercial message. So it's important for the marketing team to meet this checklist here under CAN-SPAM with every promotional email it's sending. First, under CAN-SPAM, you don't want to use any false or misleading header information or a deceptive subject line. So if your subject line says you could win a $50 gift card, then the message of the email needs to include information about how to actually enter into a contest involving a gift card. If not, that's going to be a deceptive subject line. You also need to identify in the email that it is an advertisement and provide a physical address for the organization sending the promotional email. And most importantly, under CAN-SPAM, you need to provide an opt-out instruction. So the good news is CAN-SPAM uses an opt-out approach. So you don't need consent before sending marketing emails, but every time you do send an email, you need to provide that right to opt out. And you want to make sure that that opting out is super easy. It's uncomplicated. Anyone can do it. We see this really often at the bottom of our promotional emails. You just click the unsubscribe and it either unsubscribes you fully, or it takes you to another menu where you can decide what type of messages you want to be unsubscribed from. And once a consumer opts out of your messages, you really want to honor that quickly and usually within 24 or 48 hours. And lastly, you want to monitor what others are doing on your behalf. Obviously, this isn't really a check mark that you can do in terms of checking within the promotional email. But under CAN-SPAM, if you are hiring another company to handle your marketing, both the company whose product is being promoted or service is being promoted and the company that is sending the email can be held liable. So you want to make sure that when you hire another company, they are also following this checklist here. And so next I want to move on to texting and calling advertising. And the two main laws in play here are the Tcpa and the TSR. The Tcpa is the Telephone Consumer Protection Act, and it restricts telemarketing and the use of automatic dialing systems, including through text messages. And the second player here is the TSR, which is the Telemarketing Sales Rule, which prohibits fraudulent, misleading, and harassing telemarketing calls. So first I'm going to go through the Tcpa. The Tcpa is enforced by the FCC, and it provides for a private right of action along with statutory damages for every single text and phone call that is in violation of the Tcpa. The risk is high here with the Tcpa. There have been many class action suits under the Tcpa amounting to a large amount of damages, so it's really necessary to consider what the Tcpa requires. For purposes of this presentation, I'm going to touch solely on promotions and advertising calls and text messages, but the Tcpa does apply to other types of calls and texts as well. So for purposes of promotions and advertising, it's key to know that any text or call that is being sent to a cell phone and uses an auto dialer, you must obtain prior express written consent. Now, express written consent can sound like you need to send a form to a customer, have them sign it, have that signature in order to start sending them calls and texts. Obviously, this wouldn't be very convenient. It wouldn't be very viable. Now, technically, you can do this. More power to you if you don't like to be sending those forms to customers, but you can also use a website form submission, like the examples I have here on the slide from Ann Taylor and the SIL, where they are specifically saying, if you provide this telephone number, we are going to send you promotional text messages. That is express written consent under the TCPA. And so that's more of a convenient options for organizations who are looking to send promotional text messages. Now with the TCPA, it's really important also to recognize that even with express prior consent, you must provide an opt-out mechanism with every text message and with every call. So with text messages, you only have to provide it in the first message you send. I have two examples here from Subway and a Zoe's Coffee. And you can see in that message, it says text stop to unsubscribe. So that's that opt-out mechanism that is necessary in order to comply with the TCPA. And once you receive that stop message, you can then follow up and confirm an opt-out. But you need to make sure that that's going to be provided in every single text message, even if you have prior express written consent. So the TSR, the telemarketing sales rule. The TSR is enforced by the FTC, and it applies to organizations that are making telephone calls that are intended to promote goods, services, or contributions. The TSR has a long list of requirements, and this isn't a complete list that I've provided here. It's just a brief overview. But it basically comes down to don't make misrepresentations and make certain disclosures. So with the TSR, you should only be making telemarketing calls between 8 a.m. and 9 p.m. local time. You need to be transmitting caller ID information. You need to retain records about the calls you're making. And one of the most important requirements is to screen and scrub names against the National Dnc Registry. The Dnc Registry is the Do Not Call Registry, and that's where U.S. residents can register a phone number in order to not receive calls in the future for telemarketing. Now, if you're making a lot of telemarketing calls, there is a safe harbor for the Dnc Registry. So if you qualify for this safe harbor, you can have protection against an enforcement action in case you do violate the Dnc Registry. You call a name that's on that registry. So certain conditions for qualifying for that safe harbor may include training your personnel and implementing written procedures along with other requirements. So if you are making telemarketing calls, if that's the way you're advertising, this could be a good path moving forward to try to get to qualify for that safe harbor. So next, I want to touch on some general privacy law considerations, and I'm going to start here with CAPA. CAPA is the Children's Online Privacy Protection Act, which, as the name suggests, it regulates children's online privacy. CAPA applies to both operators of websites and online services directed to children under 13, and it also applies to operators of websites and online services with actual knowledge that they are collecting information from children under 13. So if your promotion is geared towards minors, you 100% want to consider CAPA, especially if it's geared towards children under the age of 13. And even if it isn't geared towards children under the age of 13, if you have actual knowledge that you may be collecting personal information from children under 13, you still need to comply with CAPA. Now, the biggest hurdle with CAPA is operators covered by CAPA must provide notice to parents and obtain verifiable parental consent before even collecting that personal information. So verifiable parental consent isn't going to be as simple as just obtaining a nice opt-in checkbox. You actually need to be able to verify that this is the parent who's providing the consent for you to collect their children's personal information. So there's many different methods for doing this. You can have them sign a consent form and send it back to you. You can have them call a number where they can answer a few questions, but you absolutely have to obtain this type of consent before collecting the personal information. CAPA also requires certain disclosures within your privacy policy. So if you are collecting personal information from children under 13, you need to disclose that in your privacy policy, whether that's within your overall privacy policy or a separate COPPA privacy policy. Which actually brings me to my last slide here, covering generally what you need to consider with privacy policies. When considering what to include in your privacy policies, you need to consider what privacy laws are applying. For example, the GDPR and the Tcpa, which are the EU's privacy policy and California's privacy policy, both those laws require extensive disclosures within the privacy policies. And so you want to make sure that you're meeting all of those requirements. For purposes of this presentation, I'm just going to briefly touch on what to include in privacy policies for promotions purposes. But if you have any questions regarding any of those laws and what they require, please feel free to reach out to me after the presentation. So promotions are generally going to be collecting personal information, whether you're obtaining an email address, a name, a phone number, a physical address, that is all personal information. And so when you have an online privacy policy, you want to disclose that information there. For promotions, I've seen it where you can include a separate promotion section, or you can incorporate it into the different sections within your privacy policy. Here on this slide, I'm showing it in your different sections in a privacy policy. So including in the what information is collected category, you're stating, with our sweepstakes, we are going to be collecting a username and password. And then under the how the information is used, you're explaining that when you're sending marketing communications about promotions, you're using that personal information that you have previously collected to do so. And then also disclosing how that information is being shared. If you're sharing a customer's personal information from a promotion with third parties, you want to disclose that in your privacy policy as well. You also maybe want to consider whether you are selling personal information collected in a promotion, and depending upon the privacy law that applies, how that personal information is being retained and for how long. So that is all I have for the privacy law specific considerations. That was a very quick overview. And again, I'm happy to answer questions outside of this presentation for more in-depth details. But now we're going to open it up for questions, even though we have like 2 minutes. But Tara and I both can maybe answer a question now.
Yeah. So it looks like we actually got quite a few questions, so we probably will not get to all of them today. However, like I said, we will follow up with specific answers to these questions via email. And again, if you have any other questions maybe you didn't submit, or if anything comes up, please feel free to reach out to either of us. We're always more than happy to answer questions in this area. The first one that I see is a question about banner advertisements. So it says, for a banner advertisement, does the disclaimer need to be shown every time, or can a link through the banner have the disclaimer a consumer needs to scroll past to enter? Does that adequately protect me? Best practice would be to have it on there every time. Again, all of this is on a sliding scale of risk. So I can't say that, yes, you will 100% be protected, or no, you will definitely not be protected. Best practice, like I said, is to make sure that you're including it on every advertisement that's going out. If there are some practical limitations as to why you can't, I would recommend reducing your risk by using maybe a shortened disclaimer like I talked about for some of the social media aspects, but make sure that when you click on that advertisement, I recommend it be one click away from the full official rules so that they can see all of the details of that particular promotion once they click on that ad. Another thing to think about that I know has come up for a couple of clients before is additional compliance with the Americans with Disabilities Act. Apparently, you need to include like a verbal description of what the ad is and sort of where it goes. And sometimes it can be very difficult to include. I understand the character limits on that are very, very low. So sometimes it can be difficult to actually include all of that information in the banner ads. Again, sliding scale of risk. So I always recommend if for some reason you can't and you just have to use that particular asset, reduce your risk by making sure it's one click away from the official rules and include as much information as you possibly can. It looks like we got a question about, will the session be recorded? Yes, it will be recorded, and you will receive a link tomorrow, I believe, via email to the recording that you can share with others or watch again at your leisure. And there should be a resources tab as well if you would like a copy of the slides. I believe it's available under a resources tab in your overlook for the platform. There was a question about the up to language in the example that I gave about making sure you're not including potential advertising claims relating to a promotion. Yes, the up to language is what made that a claim, because you're basically saying that that is what your consumers can expect to receive in exchange for participating in this promotion. So it would be okay to use it without those two words. I just recommend that it be accurate. So if there's some sort of limitation in terms of who's actually going to win, I would maybe lower that value to what most people can actually expect to receive. I understand from a marketing perspective, it might not be as sexy and it might not be as intriguing to people, but you want to make sure that you're not going to get yourself in hot water by having somebody clicking, thinking that they're going to win $1,200, $2,500, when really they're probably going to win an amount substantially less than that. Let's see. Oh, this is a good one. Are there rule templates that we can use, buy, or rent? There are. I'm sure you can find anything on Google. I don't necessarily recommend using anything that you find on Google, but sometimes if your budget is very limited, or you're wanting to review it you want to put a draft together to have your legal counsel review without paying them to actually draft it. Take a look at what similar contests your competitors have run and start there. You will want to get it reviewed by your legal counsel. I never recommend just taking something you find online and running with it. I have often seen rules that have been drafted by third-party fulfillment companies as well as also an option. These are companies that kind of specialize in running promotions for companies. They know the process, they know what documentation is required, but I still often find issues in the rules of them copying and pasting from prior promotions that they've done for other clients, for example, and not everything that's in the official rules document is actually applicable to what you're doing. So each promotion should really be treated as its own separate set of documentation, its own separate living thing. But you don't necessarily have to start from scratch every single time. And we, just as a plug for me and Shelby and Husch Blackwell, we do have some templates that we have used to keep the cost down for drafting these kinds of documents for clients. They're templates that I and my other associates have put together to try to make it as efficient as possible when we're putting together these documents for you. So always check with your legal counsel. It might not be as expensive to sort of put this type of documentation together as you might think. At this point, we are over time, so I am going to cut off questions here, but do please submit questions. If you have them, we will, again, respond via email. I understand apparently the resources tab is not working for someone, so if you're not able to get a copy of the slides, please reach out and I'll make sure to send them to you, or Shelby will send them to you. But I have a little spiel I'm supposed to read. So thank you for joining us today. We hope that this information was very helpful to you and that you found it interesting. Please join us on May 18th for our next installment on this IP webinar series, where we will cover some false advertising issues. As a reminder, this program has been approved for CLE. To report your hours, click on that CEU icon at the bottom of your screen and you'll get a certificate of attendance tomorrow, including course numbers via email. And again, you'll get a recording of the webcast for watching and sharing. And if you have not done so already, please do complete that survey so that we can get your feedback on this presentation and if there's any other topics that we can cover for you in the future that are of particular interest to you. That concludes today's webinar. Thank you both. Thank you, Shelby, for joining me, and thank you to the audience for tuning in today.